Hi guys, it's Kathy. I hope you're doing well. I finished all editing, so we're gonna see her question Bell this stream, and then next stream we finish. So today's Thursday. We're gonna finish Friday morning, and we're gonna find out if it's dismissed or they move forward tomorrow morning. But to get there, first we gotta see her question him. Here we go, guys.
We are live.
Mr. Bell, do you want to resume the stand?
Well, before Mr. Bell gets up there, Mr. Duckett and I discuss entering into evidence joint exhibits. So with Mr. Duckett's agreement, Mr. Duckett, can you help me? So can you do 1 through 2? 1 through 3, and hand them up?
Oh,
Okay. You look confused.
I'm not sure what you
Dude, that would be crazy if they just dismissed it here.
need help for.
Because I'm gonna do 3, so we can make this quicker. I'm gonna do 4 and 5 and 6. So these are the,
Why don't we take them one at a time?
yeah, that's why I want him
Tell us what
to,
each one is.
right, that's why I wanted to do it with Mr. Duckett. So Mr. Duckett, you have
J1, 2 copies of J1, 2 copies of J2, and 2 copies,
it should be 3. Isn't it 3?
3 copies, 4 copies, 5 copies of J3, 2 copies of J1, 2
Ends. It's not
Let
gonna
me
end,
just
though.
let me ask this, because we can deal with the copies later, but
Okay,
can
we could,
someone just say for the record, one at a time,
Mhm.
the exhibit number and what the
okay,
title of the
I can
exhibit
do
is?
that.
Sure.
Yeah, I can do that, yes.
And then we can
Okay.
deal with the copies later.
Okay, J1 is, I'm sorry. J1 is in the Miller case, the case management conference report that Judge Anders testified to, and Mr. Bell testified as well.
Which there were 3, right? So which one is that? The
This
one
is
that-
Miller versus Coulter.
Right.
This is the case management conference report. Okay. J2 is in the Anthony Miller case, is the case management conference memorandum filed by Mr. Bell. J3, I didn't get J3 back. Oh, here's J3. J3 is in the Miller case. It's the case management conference memorandum filed by Mr. Hubbard. J4 is in the Myers case. This is the case management conference report. J5 is the case management conference memorandum filed by Mr. Bell. And J6 is the case management conference memorandum filed by Mr. Hubbard.
And you both agree that these should be admitted?
Yes.
Okay. So those will be admitted, and you can distribute copies of that later on, unless any of it's going to be used in the questioning, in which case you can do it at that time.
No, I don't think so.
Okay, great. And I assume Mr. Duckett will come back to you after this last witness about any exhibits that you want to offer into evidence.
Yes.
Okay,
Okay.
Mr. Bell. And Mr. Bell, you're still under oath.
Yes.
Okay. Salmons, you can
Yes.
proceed.
Thank you. Mr. Bell, can you turn to ODC, if I can get to it, ODC 25?
Give us a moment.
Okay.
Okay.
What number was it?
25, ODC 25.
I have it right here, sorry.
Okay, no problem. Everyone on the page?
Yes.
Okay. Mr. Bell, yesterday you testified that you were given permission not to go to arbitration. Isn't that correct? That's what you testified to?
Yes.
Okay. Now, you would agree that there was no specific order entered by any judge that told you that you were excused from arbitration. Isn't that correct? No specific order using those words. You are excused from attending arbitration.
I had the court order from Judge Patrick.
Okay.
Let him
Thank
finish
you.
his answer.
My question to you is, I understand you had that order from Judge Patrick. I understand that. I'm asking you, was there a specific order entered from any judge that said you were specifically, I forgot the word, excused, I'm sorry. Specifically excused, you and your client were specifically
YouTube
excused from
and
attending
Twitch.
arbitration.
No, there was no
Okay.
order that specifically said that.
Thank you. Now, I understand that Judge Patrick entered her order. Now, when the order was entered, the arbitration order originally was scheduled on June 8th, 2020, and that's page, I have the little tabs. That's page 1452. The arbitration hearing scheduled, it was scheduled on June 8th, 2020 at 12:13, correct?
Yeah, if it says that, yeah.
And then Judge Patrick entered her order on the same day, June 8th, 2020. It was actually signed on June 4th, but was entered on the record on June 8th, 2020 at 3:31 p.m., correct?
Yes, that's what it says, yeah.
Now, the arbitration was eventually scheduled for January 20th, 2022, correct?
I don't recall these dates, but I don't.
Okay, well, let's go to 1454. At the bottom of the page, where it says the arbitration hearing was scheduled on, not for that date, but it was scheduled on November 4th, 2021. You see that?
I see it.
I'm sorry, could you just,
1454.
yeah, okay.
And if you turn to 1455, that's where it says it actually is scheduled for January 20th, 2022. You see that? The top of the page.
Yeah, I see it.
Okay.
I see it.
Now, between the time that Judge Patrick signed her order, let me go back, strike that. Turn to 1450, please. Where it says case management order expedited track. It's February 6, 2020. Are you there?
Yes,
Okay. Now, at one point, you did file for extension to extend the discovery deadline. Do you recall you did that in this case?
I don't remember all the details. If it's there, then I did it.
Okay.
I'm not disputing that.
Well, this, I want you to say it on the docket. So that's 1453 at the bottom of the page.
I see that.
Okay, and it was granted, right? Your motion for extraordinary relief to extend the discovery deadline. You see that, correct?
Yes, that's
Okay.
accurate.
Now, going back to 1450, This sets forth the dates and deadlines for this case, correct?
It's a scheduling order, so.
It's a scheduling order. Okay, thank you. Now, number 6, it says, a settlement conference may be scheduled at any time after August 3rd, 2020. Do you see that?
Yeah, you see it.
Okay. Now, was a settlement conference ever scheduled in this matter?
I don't remember.
Okay. If I tell you that it's not on the docket, would you?
I'm not disputing that.
Okay. Now, also number 7, it says a pretrial conference will be scheduled at any time after October 5th, 2020. Do you see that?
I see that.
Was a pretrial conference ever scheduled in this matter?
Never was.
Now, normally, when the case goes to a jury trial, those things happen, correct?
What happens?
A settlement conference and a pretrial conference.
That's accurate.
And in this case, neither one of those happened, correct? Neither one was scheduled.
That's correct.
And in this matter, you can file a motion or any document or petition to have a settlement conference?
I don't know. I'm not sure. I don't remember every detail, but I don't recall that.
Do you recall whether or not you filed a motion or a petition to have a pretrial conference?
I think I answered that. I don't recall.
Okay. Now, between Judge Patrick's order that was signed on June 4th, but entered on the record was entered on the record on June 8th, and the arbitration hearing, which was eventually scheduled for January of 2020, you didn't take any steps to clear up the discrepancy between Judge Anders' orders and Judge Patrick's order, correct?
That's wrong. I did everything the law required me to do to get this case put back in a major jury.
And what were those steps, Mr. Bell?
I had a court order from Judge Patrick, and then I did petition to get the court taken out of arbitration with Judge Wright. He denied that without prejudice. I did what I had to do to get the case to a jury trial, to comply with the arbitration statute. I did what I could do.
Okay, and when you talk about Judge Wright, you're talking about the Myers case, correct? You're not talking about the Miller.
Remember.
You're not talking about the Miller case, right?
I don't even. I know I did what was available to me to try to get this matter resolved. That's all I hear you could say.
Okay, since you brought up the Myers case with Judge Wright, he denied your motion to have it transferred to out of arbitration, correct?
Without prejudice.
Okay, right, without prejudice. So my question to you is, again, I understand you filed the motion to have it transferred. Judge
He filed the one motion, lady. That means he did everything he possibly could to get this case going. Everything. Not pre-trial, but that doesn't matter.
Patrick granted your motion. But my question is and I'm talking about the Miller case. I'm not talking about the Myers case, the Miller's case. And if you want to refresh your memory, you can look at the docket. It's right in front of you. Between June 8th, 2020, when it was entered on the record, Judge Patrick's order, and the arbitration date, which was approximately, I guess, a year and a half before it occurred in January 2022, in the Miller's case, what steps did you take to clear up the discrepancy, since you didn't have a pre-hearing conference scheduled or a settlement conference? What steps did you take to clear up this discrepancy to make sure that your clients were excused from arbitration?
First, the arbitration statute says you're excused because the arbitration program does not have the jurisdiction to grant them the relief that we were seeking, first and foremost. And then what did I do? During this time, we was gathering more discovery and developing the case, depositions of witnesses, and
Gathering discovery and developing the case, and then he filed that motion.
I sent the client to
Everything
get
you
some
could do.
medical evaluations, Mrs. Myers, and it was developed in case we were preparing for trial. We had our exhibit binders and everything. We were working on getting all that together for a jury trial. So
He was
whatever's
gonna
on the
make
docket here
binders.
shows that I filed motions. I just did what the law required, what was available to me at the time. Whatever the court does, but I complied with the law. Everything I did was guided by what the arbitration statute says, that my complaint was proper. I listed everything that was listed, that I was supposed to put in my complaint to invoke the major trials jurisdiction over this case. I can't control what the judges do.
So it's fair to say that after Judge Patrick entered her order and before the arbitration, you didn't file anything with the court? It's fair to say that?
About
Whether or not your clients were excused from arbitration. I'm not talking about you reading the statutes. I'm saying it's fair to say that you did not file any motions or petitions with the court and got a court determination that your client was excused from arbitration.
I already did that. If the court granted the motion with the Judge Patrick, like, what else do you expect me to do?
Okay, Mr. Bell, thank you. Now, you recall seeing Judge Patrick's, strike that, Judge Wallace's opinion, correct?
Right.
Okay. I'm going to Exhibit 39. And I'm going to 1659. The first full paragraph.
So, all right. This whole thing is happening because he did not go to arbitration. And he did not fill out his case management conference report correctly. So, all that other stuff that he brought up, the racism, the conspiracies, all of it, vendettas against him, that has absolutely nothing to do with this, with anything here, because she is just trying to prove that he behaved badly by not going to arbitration and not filling out the case management conference report. That's all she has to prove. That's all she has to talk about. It's all she has to prove. He doesn't have to prove anything. You know, he's the defendant. He's innocent until proven guilty. But he brought in all that other stuff. And I don't see how all that is even relevant to what her problem is with him. You know what I mean? Their problem with him is how he acted with the Miller case and the other case. I can't remember now. But because he's not going to arbitration and filling out the paperwork right. Nothing he says has anything to do with any of that. When he was on the stand. He is on the stand. I mean,
Miller's argument that he was nevertheless excused from attending arbitration due to Judge Patrick's order is untenable. You see that?
I see that.
And also where it says, nevertheless, Miller does not deny that he received Judge Andrews' order. Do you see that?
I see all of that. I recall this very well.
And also, Judge Wallace, as well as her two colleagues, stated Miller had from early November 2021 to January 20th, 2022 to obtain clarification on the discrepancy between Judge Patrick and Judge Andrews' orders. Rather than doing so, Miller's attorney defiantly refused to bring the issue before the trial court. You see where that is in opinion?
Yeah, I see that. I
Okay.
disagree with it.
But what what the judges of the Commonwealth Court stated in their opinion is actually accurate, correct?
When they talk about the facts, yes, as they happen, but I did comply with the law. I don't agree with that at all. Why is everything my fault?
Okay. Also, it says down the bottom of the page at 1659, Miller's attorney made it abundantly clear that Miller's excuse for not attending his scheduled arbitration was not that he was confused by Judge Patrick's order, nor that he was relying on Judge Patrick's order. Do you see that?
That's not accurate.
That's not accurate?
I never told that to the judge.
Okay. And also, do you see on the bottom of that page, accordingly, the trial court did not abuse its discretion in determining that Judge Patrick's order did not provide Miller with a reasonable explanation or legitimate excuse for failing to appear at arbitration. You see that?
That legal conclusion is wrong.
And as you stated before, once you received this opinion, you didn't file an appeal, correct? Correct? You didn't file an appeal once you got this
A
opinion.
petition for allocator, a request for permission to.
Mr. Bell, you didn't file anything with the Supreme Court of Pennsylvania, correct?
Yeah, because the Supreme Court doesn't hear anything. The Supreme Court is not an error correcting court.
But did you file a petition for allocator?
I was not required to.
Okay. Now, Mr. Bell, in regards to the complaint that was filed
He definitely did
by
that.
Judge Wallace, do you remember your response to
Yes.
the petition, for the
I remember.
DB7? Do you remember that in that DB7 response, you included a copy of the opinion or memorandum in Carroll versus Anders, Judge Anders' brother's case?
No, wait, no, that's not accurate.
You did.
You said in my response to a DB7, I put Carroll versus Anders?
You included a copy of it. Let's go to,
Well, if it's in there, then it's in there. Yeah, I'm not disputing that if you have it.
if you want to go to ODC 55. And that's the answer to the DB7.
What,
Let me get to the 2087. Yes.
Sorry, what page?
2087. I'm trying to get to it too. A lot of pages.
I'm there.
Okay. Well, first of all, ODC 55, that's the response that you filed for this office. In regards to the DB7 that Judge Wallace filed. Is that it?
Wait, hold on. You said, all right, so you directed me to,
It's the same exhibit.
I did that. Yeah, but it's.
Hold on. What do you need clarification on?
All right, so she directed me to 2087. I'm at 2087. I don't, this document is huge. I went to the page you directed me to.
Okay.
I'm just trying to address what's in front of me now. So I need to see if this is the DB7 of my response that you said it was.
Okay.
I need to go to the first page of it.
Okay, well, I'll help you out. It's 1886. ODC 55.
I see. Yeah, I probably put that in here. That's
Okay.
accurate, yeah.
So this was 2087. You included the memorandum from the court in your answer to the DB7, correct?
That's it, yes.
Okay. And you included this in regards to our allegation of the motion to recuse that you filed against Judge Anders, where you mentioned the Chief Anders federal court case, correct?
I know it was in my 51 motion, and I know there was an because the DB7, it wasn't really clear on what was, I guess, it wasn't like precise on allegations. And so I assume that, when it mentioned that, we mentioned, Judge Anders' brother's case in the whatever I filed, I thought you were saying that I just made this up.
I didn't say you made it.
I don't know, just how when you read it, it seemed like, so I said, this is real, I didn't make this up, and I put that in my response. Yes, so yes.
Okay, so that was part of your response to the DB7. It also, you alluded to this, or not, you didn't allude to it, you stated in your motion to quash, strike that, motion to recuse, in the Myers case, you mentioned Chief Anders' federal lawsuit that was filed against him. You mentioned that, correct?
If it says that.
Okay, now, if you go to 2087, the date of
He mentioned it to everybody who would listen, even me.
the memorandum is November 7th, 2019. Correct?
Yes, on the top.
And this was entered in the evidence on 11/7/19, and this was before your two motions to recuse Judge Anders. You filed a motion to recuse in June 11th, 2020, and then you filed another motion to recuse in the Myers matter, which was after, I believe, June 11th, 2020.
He never met a judge he didn't want to recuse.
And I have to get back to the document for the date. You recall that you filed that in the Myers matter, you mentioned this case, correct?
It's in there.
Okay.
It's in there.
And the November 7th, 2019 date was before. So you were able to find out about this case before you filed the second motion to recuse, correct?
So, I guess, temporarily, but yeah, I guess.
Okay. Mr. Bell, I don't want you to guess. So,
I don't think I understood the question.
okay,
Sorry.
that's possible. I'm sorry that you didn't understand it.
Can I extra clear? So are you saying that?
Well, let me rephrase so you can be clear. Okay, so let's go to 44, ODC 44. And let's go to,
Just give us a moment.
I'm sorry.
Some of the binders have that in a different binder and some of them don't.
I know, I'm sorry.
I got 44.
Or maybe it was the precise statement.
Ms. Ammons, I would encourage you to get to the point on this quickly.
Well, okay, I will
I
try.
think we understand where you're going with it.
I will try, I want to make a full record when it goes up to the board and the court. So I'm going to get to the point. So, I'm going to show you something, and I'll show it to Mr. Duckett, so he can have a copy. Here's your copy. This is the docket to the Carroll versus Anders matter.
Copy for us.
If Mr. Duckett doesn't, if he does, I didn't have, it's not in evidence yet, so this is on rebuttal. I do intend on offering into evidence, but Mr. Duckett, would you object to?
He gets to keep his copy.
Yeah, no, I have copies. I made sure I had copies today.
Oh, I understand.
For everyone. Do you oppose me handing it to the panel?
Yes.
Okay.
Yeah.
Well, let's continue with the questioning. Mr. Bell, this is the docket, as I said, for the Anders versus Carroll matter. And up top, it says date filed, which is May 13, 2019. And then right
I
underneath
agree,
that,
Jasmine.
it says date terminated, March 25th, 2020. Do you see that?
I see.
Okay. Wouldn't you agree that this case was terminated before you filed your motion to recuse?
was the date of my motion to recuse?
Well, the first one was, I think, June 11th, 2020. And the second one was, let me show the date. Was October 2020,
All right.
okay? And wouldn't you agree that when you filed your concise statements, when you filed appeals on both the Myers and the Miller matter, that this case was terminated prior to you filing your concise statement?
But these cases were active when he put the cases in arbitration, wasn't it? But to
Okay.
answer your question,
Okay,
when I filed, to answer you,
Let him finish.
okay, you can finish.
but to answer your question, that would be accurate, yeah. It is accurate that when, the 1925 statement was submitted to the court, this case was disposed of,
Okay,
yes.
and you admit that when you sent in that attachment to the answer to the DD7, that this case was terminated. This case had been terminated.
Yeah, it was terminated for
Okay.
years, all these cases were terminated.
Okay, so let me show you, and I'll show Mr. Dockett as well. This is a memorandum filed in Carroll versus Peter Anders with the date of March 25th, 2020. Do you see that?
I see that right here.
Okay. Turn to page 19.
I object. This is for the foundation. She asked him about this document. She hasn't made any foundation with regard to whether my client recognizes the document, has any personal knowledge about the document, has reviewed the document. She's just handed him an exhibit and asked him a question.
Normally, you would seek admission of a document before you ask questions about the content of it. So
Okay.
I don't know if you want to move its admission now.
Well, I'll ask for judicial notice of this document. It was filed with the court on 3/25/20 in the Carrolls versus Anders matter. Mr. Bell made this an issue.
Well, we haven't seen it yet, so we can't take judicial notice of
Okay.
anything that we haven't seen. If you would like to show it.
I would like to show it. I asked that it be taken.
Normally, Mr. Duckett, a public court docket would be something that we could take judicial notice of or admit. Do you have any objection to us?
I do, because this is in the docket.
Okay, well, I don't know what it is because nobody's shown it to me yet.
Well, how about if we take judicial notice?
Let me ask, Ms. Hammond,
Sure.
what is this document?
This document is the final memorandum in the Carroll versus Anders matter. Mr. Bell, his defense says that Judge Anders appeared to be racially biased based on the case that was filed against his brother. He brought that up, not me. So, in his motion to recuse, in his concise statement, and also in the DB7 answer that he gave to our office, he said that Judge Anders appeared to be biased based on this case that was filed against Judge Anders' brother. I think it's important to show that this case was done prior to the motion to recuse, his concise statement, and the answer to the DB7. So this is the opinion in this case, and it shows why the case was dismissed. The attachment that Mr. Bell put in attached to his DB7 says that the Judge Anders motion, and let me get to the page. It's page 12, which is Bates stamp 2098. We denied Chief Anders' motion to dismiss Mr. Carroll's due process claim. So I think it's important for the panel. I think it's important for the disciplinary board and the court to see these documents and hear testimony that when he included this in the DB7, when he included the allegation against Judge Anders in the motion to quash and the concise statement, that this case had already been concluded And I wanted to question Mr. Bell, like, did he see this document? He said he researched. He researched and he found this case. If he found this case when he did research, and especially in the Myers matter, which the motion to recuse was in October 2020, if he conducted research to find this case, he would have found the final opinion in this matter, and he would have found that the case had been terminated in March of 2020.
So, okay, so first of all, let's take a step back. And I'm sure you do, but I just want to try to organize this a little bit. So the last document was the docket, correct?
No, the first document was the docket.
Right, the last one we saw before this one, that was the document?
Yes.
Okay. Is there any objection, Mr. Duckett, to the committee receiving the docket? Which I think normally would be, there would be information I think that we could take judicial notice of, but I want to know your position about that. Just so we can understand the dates that various things occurred.
Right, no objection.
Okay. So, Ms. Ammons, could you give us?
I will give you the docket.
Of that.
Thank you.
Okay. And so, before we get to this opinion, I have some questions about this and the dates.
Okay, good. Now we get to hear the panel ask a couple questions. Good, good, good. So we can sort of figure out where their minds are.
Which exhibit, Ms. Ammons, is the Miller docket in the Court of Common Pleas?
But the Miller docket is 25.
Okay.
That's the docket.
And
No. Chief Anders did not go in front of Judge Anders. He filed lawsuits against multiple lawyers. Oh no, I can't remember. Words are hard at 4 o'clock in the morning. The whole judicial, like the DA's office, but civilly. I can't remember. The Philadelphia, the police departments, the judges, the lawyers, and the whole office. But I can't, the word is not coming to me. Anyway, there was like 4 different cases that he cited, saying that in his case, all right, with his clients, it appears that Judge Anders is racially biased, and he cited a different case that Chief Anders was in, that Miller was in with Chief Anders. Miller is one of the lawyers that he sued. Okay, so Miller was with Chief Anders in this other case. Judge Anders is his brother, and he sued Miller. So he's like, oh, well, definitely biased, because what I did there with your brother's case and that lawyer, you're biased.
the date of Judge Anders,
Motion to quash, motion to recuse, I don't know why.
the date of Judge Anders' order placing the case into arbitration was February 27th, 2020.
Yes.
Right.
Yes.
And on February 27th, 2020, was the Carol V. Anders case still pending?
Yes, it was.
Okay. And the motion to recuse Judge Anders
Was June 11th, and that's on 1453.
June,
It was June 11th, it looks like, June 11th.
June
20
11th of 2020.
Of
And on
2020.
June 11th of 2020
Correct.
was the Carol D. Anders case pending?
No, it was done. It was terminated in March of 2020.
And I object to that mischaracterization. You have the document in front of you. If you look at the last few pages, there's still entries in 2021.
It says date terminated 3/25/21. I understand there was docket entries, but
On the first page.
I understand it was docket entries, but this is the final thing where it was this, motion for summary judgment, it was granted.
Well, but hold on, Mr. Duckett. But there are docket entries in this case that go through March 31st of 2021.
Right.
When,
But the final order where motion for summary judgment was granted was on March 25th, 2020.
And I object to that mischaracterization of that document.
yeah, look, I mean, I think that the dates on the docket establish the facts of when different things happen. If you want to ask Mr. Bell as to this memorandum, actually, I can't recall if you already asked him.
I didn't ask him anything, it was an objection.
Okay, so why don't you show it to him for identification and ask him if he's seen it before? And then if there's an objection to further questioning about it, we'll deal with that then. But I think it's fair for you to ask him, has he seen it?
Mr. Bell, when you conducted your research in June, when did you conduct your research and found Chief Anders' case?
I don't have an exact date. I just remember I came across this. Yeah, I mean, I don't remember the exact date.
Okay.
I don't. But if it's in my motion where I mentioned this, it had to be around that time. But I do recall I heard something about this, but I didn't believe it at first, and I kind of ignored it until I had a chance to look at it just to confirm.
So when you did your research, you did not come across this memorandum?
When I did my research.
When you did your research?
Yes, when I did, I discovered, this appears to be that. I don't know if it's you're not committing fraud, I know you're not. So yes, this appears to be.
So I just think the record's a little unclear because we're referring to things like this document without saying the specific one. And when we go back to read the transcript, it's going to be very confusing because there are two different memoranda that are being talked about here. And I think it'd be helpful if you could refer to them as amendments by date in your question.
That's fair enough.
Okay, go ahead.
The March 25th, 2020 memorandum. When you did your research on Chief Anders' case, did you see this document, which is the memorandum of March 25th, 2020?
How is he supposed to know that? I mean, I research cases often when I try to tell you guys about them. I do not memorize every single memorandum that I look at before I tell you, this is what happened, this is what happened, this is what happened. How is he supposed to remember what date he may have saw that one memorandum from that whole case? Nobody could. Monica, just so you know, I don't want you to worry. Yesterday morning, I asked Brent what he had for dinner, and I told him to bite me for you.
I saw that.
You saw this. So can you turn to, since you saw it, can you turn to page 19?
I'm at 19.
Okay. 19 says conclusion. After proceeding past a substantial motion to dismiss, Mr. Carroll decided not to participate in the case. He did not appear for depositions or court appearances. He elected to not respond to Chief Anders' summary judgment motion. We nevertheless address Mr. Carroll's claims in light most favorable to him based on the adduced evidence. After this analysis, we grant summary judgment to Chief Anders on Mr. Carroll's remaining due process and race discrimination claims. Did you put this in your motion to recuse? That the case had been dismissed? That a motion for summary judgment was granted to Chief Anders?
That's totally not required at all. At all. This case was pending at the time that Judge Anders put the cases in arbitration without any hearing.
I'm not asking about arbitration, Mr. Bell.
All right.
I'm asking
No,
about.
I did not. That's not required. It wouldn't even be necessary.
Okay, thank you. I will ask the panel to take judicial notice of this memorandum. It says Mr. Belt did identify that he saw this.
Objection, Mr. Duckett?
Yeah, I still object.
What's the objection?
Even though Mr. Bell said he saw it, I don't believe that Ms. Ammons made out when he saw it. And I think that makes a difference. Part of his testimony was when
You can redirect him on that issue if you'd like.
right, but I don't think that she has made the sequence of events that he saw this prior to filing his motion for recusal.
That's not a legal objection.
Well, I guess the transcript will speak for itself on that, but if you'll have the opportunity to do some redirect if you want on that issue. As far as judicial notice, Ms. Ammons, we'll take that under advisement when we do our report and recommendation. I presume though, Ms. Ammons, that you don't object to us taking judicial notice of any of the filings in this case, including the ones that occurred after that order, including the motion for relief of judgment filed in March of 2021.
I think that's part of my exhibits as well, but no. If anything is filed in the federal court case or the Miller or Myers case, I have no objection to judicial notice.
Right.
In those three cases, I have no objection to judicial notice. And I'm going to mark these. The United States District Court.
I'm sorry, we're talking about the Carroll v. Anders case. You're asking us to take judicial notice of certain filings in Carroll v. Anders.
Correct.
I'm saying that presumably you don't object to us taking judicial notice of any of the filings in Carroll v. Anders.
Oh, no, I'm sorry. I misunderstood what you said.
Okay.
No, in the Carroll v. Anders, no, I'm sorry. No, I do not have a problem with any
Right.
judicial notice.
Just because, we're not gonna get into a whole, collateral issue about all of the filings
Oh, no.
in Carroll v. Anders. There's a number of
Wait, you just
items on this docket, 61 docket entries, and we've talked about 2 of them.
Mhm.
So there's another 59 that the committee can also take judicial notice of.
Because
Necessary for the content.
nope, because Mr. Bell testified about this on direct and on cross. I have no problem with any of these documents being entered into evidence.
Okay.
That's not whatsoever.
Okay. Well, I don't know if the docket technically needs to be entered into evidence for us to consider it, but it might make the record a little bit simpler if it was, but only if there's no objection from any party about the docket.
Of course, I don't have it.
No objection about the docket.
Okay.
Still remains about the memorandum.
So will we call this
This is going to be ODC 58.
okay,
The docket will be ODC 58.
okay. Ms. Henderson, you're gonna say
Yes,
something?
can we take our first break when it's most convenient for everyone, please?
Yeah, I think that this is Are you gonna have any more questioning on,
Oh, yeah.
I know you're having more questioning on Carol V. Anderson.
No, I do not have any more questions on Carol.
Okay,
Anderson.
and I think we haven't, and I said we'll reserve the issue of whether to take judicial notice of specific filings within this until we write our report and recommendation. You can certainly make arguments about it in your post-hearing briefs. Let's take our break.
Okay.
10 minutes, please. Thank
10
you.
minutes? Thank you.
Yeah, 10 minutes. Thanks.
We're live.
Evans, you can proceed when you're ready.
Okay. Mr. Bell, you testified extensively yesterday about case law,
That's accurate.
and that is your Exhibit 42. Now, isn't it true, the case where you said that the Judge Wallace got it wrong was the Catherine Hall and Wayne Hall versus Mona Sue Reed? You recall testifying that?
Yeah.
Is it true that in this case, that
Sammons, could you just give us the page number?
Oh.
So we can find it?
his page is 704, 705?
So I live close enough to New York to say that I live close to New York. Close enough. All right. New York bagels, the best in the world. Oh my gosh, they're so good. Right? Well, that's because they use this substance, and I cannot remember the name of it right now, but they use this substance they're about to ban. So I need to get to New York real quick and get some bagels for the last time before they actually ban what makes them delicious. I don't know what it is. I don't know why it's bad for you. I have no idea. I just know that New York bagels are so good, delicious, and the way they make them is about to change.
In his Exhibit 42.
Just give us
Are you ready? Okay.
I don't think that.
Oh, I'm sorry. I don't mean to rush you.
It's okay.
It's just when we switch binders, it takes us a minute.
I understand.
Go ahead, I'm ready.
Okay. As I said, you testified yesterday that Judge Wallace and her panel members got the reading of the Reed case wrong, correct?
Yeah, said how they cited it was misleading, yes.
Okay. Now, isn't it true that the Reed case involves an appeal from the arbitration award? Isn't that true?
Yeah,
Okay. And the Reed matter, they're not appealing from a non-process that was entered by a common pleas court judge, correct?
if it says that,
Okay. So in your case, when you filed relief from the non-process, that's totally different from what happened in this case, correct? It wasn't, the non-process was not entered by an arbitration panel, correct? In the Miller and Myers cases.
repeat that.
I said the arbitration panel did not non-process the Miller and Myers cases. Isn't that correct?
Yeah,
Okay.
yeah, the judge did.
A judge did, okay. Now, in this case, if you turn to 706, footnote 2, in light of our disposition of this case, we need not reach the second issue presented by the Halls, which posits that Judge McGowan abused his discretion by transferring the case sua sponte to arbitration. You see that there, right?
I see that.
So in this matter, they made no judgment about whether or not this judge transferred the matter to arbitration, correct? or he just abused his discretion by transferring the case.
That's what it says.
That's what it says. Okay. Now, going to the second case that you cited, it starts on page 707. This is the Pellegrino versus Katulka, if I pronounce that right.
There.
Okay, this matter, it was originally the plaintiff filed because of alleged encroachment on her property from the defendants, correct? And that's on page 708, correct?
Yeah, I see the case.
Okay, and then the defendants filed a answer in new matter to the plaintiff's case, correct?
I don't know the details
Okay.
as far as, but yeah.
Well, you cited this case.
Yeah, I know I cited the
Okay.
case. Like, I don't know every single step that happens. I
Okay.
know what the holding is and the import of the case.
Okay, so in 709, it says that they asserted a number of counterclaims seeking declaratory and injunctive relief based upon adverse possession, irrevocable license,
Thank you for
title
the
by
cheers,
consentable
Monica. Thank you.
lines, easement by prescription, easement by implication, and slander of title. So this matter dealt with property, correct?
If it says
The
that,
counterclaims dealt with property, correct?
if it says that, yeah.
So the facts of this case is totally different from the Millers and Myers cases, correct?
No, it's not
The-
at all.
The Millers and Myers cases did not deal with property, correct?
If you look at section B of the arbitration statute that governs everything, it says, damages request in excess of $50,000 and property. So that's a prohibited, category. You can't put
Okay.
that in arbitration.
Okay. So then it says, on page 712, in the middle of the page, it says, upon our review of the certified record on appeal, we agree that our decision in Robert Half governs here and requires that the judgments in this case be vacated. You see that? You agree with that, right? That Robert Half governs this case.
It's the arbitration case.
Okay. Well, let's turn to Robert Half in your thing, in your exhibit. And let's go to, let's see, I have too many stickies.
Just so you know, what she's doing right now is she's taking all the exhibits that he entered and she's tearing them apart. They all have the red binders open because this is the defense's exhibits that she's going through right now, saying no, 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 no.
It starts with 717. Now, 717, originally, this plaintiff was seeking $35,864.74. Now, you agree that will be a case for arbitration, correct?
Yeah, so that's their damage demand, yes.
And then the defendants filed a counterclaim, and that number is on page 718 for, at the bottom of the page, $75,024. You see that?
I mean, if it says that, it says that.
And on 724, the court says, having examined the available alternatives, we conclude the best resolution of this dilemma is to hold that the following of Martin's counterclaim, which arose out of the same transaction as the original claim, immediately divested the arbitration program of jurisdiction over the entire case. Once Martin filed its counterclaim, the whole case belonged in the Court of Common Pleas trial program. Now, the facts of this case is totally different from the facts in Myers and Miller, correct? There was no counterclaim in either of these cases, correct? In the Millers and Myers cases.
That's not the issue, but to answer the question, there were no not that I recall, I don't think it was.
Okay. And page 725, the top of the page. Of course, the trial court can also remand the cases to arbitration if the court resolves through its pretrial process.
The lady in green that was sitting on the right was Judge Wallace's lawyer. So once Judge Wallace stopped testifying, once she was released, she left.
That the entire case really belongs in arbitration. Do you see that?
Yeah, I see that.
So under this ruling, which the court says governs it, the trial court can remand cases if it resolves its pretrial process through the entire case and transfer it to arbitration. That's what this case says,
No,
correct?
it doesn't. That's not the holding of the case. That's dicta, for one. And there were no pre-trial processes used because the case was put into arbitration, a conclusive determination about the value of three cases before we got that far. But this is not the holding of the case. That was the court's dicta.
Okay. But you agree this case, the facts are totally different from your case in regards to counterclaim. And the counterclaim was more than the threshold of arbitration. You agree that the facts are different?
I'm sorry, go ahead.
I said you agree the facts are different.
As far as there's no counterclaim.
Now, Mr. Bell, have there been other cases that you requested jury trials and it was transferred to arbitration?
Never.
Never?
This is the only time.
The only two cases that happened.
It's never happened before.
Okay. Now, you also mentioned in regards to
Thank you for the
Mr.
cheers.
Payton.
Thank you.
and Judge Anders' apparent or appearance of bias. Now, these Commonwealth Court, strike that. Mr. Payton challenged the sufficiency of the evidence, correct? In that appeal?
I believe he did. That was a claim. I think he raised 3 claims.
And the court found that the sufficiency claim is without merit, correct?
He did not win that. I don't know the exact language, but he didn't win that argument.
But they did remand it for further proceedings. They sent it back to the lower court, correct?
Yeah, that's
Okay.
right. Yeah.
Now, it went back to Judge Anders.
Thank you for the
You agree
flowers,
to that,
Kelly.
correct?
Thank you.
For evidentiary hearing?
That's accurate.
Okay. And Mr. Payton eventually did have a hearing. Strike that. Eventually, Mr. Payton was found guilty again after the court proceedings, correct? In June of 2017? He was found guilty, correct?
So when you say the word found, that he pled guilty and to get out right away. He didn't have the stamina to go through a trial, and I thought that was a silly decision. But
Okay, so he,
yes, he broke down. He couldn't move forward. He accepted the plea, and they let him out of jail.
so he pled guilty in June of 2017.
I don't know when he pled guilty.
Okay. And it wasn't before Judge Anders, correct? When he pled guilty?
The case was transferred to Judge Giovanni Campbell.
Right. And that was in June of 2017.
I don't know the exact dates.
Okay.
I agree with you, though. Yeah.
Oh my gosh. Thank you, Terry. Thank you so much. Look at the one the one person you just gifted a membership to. I'm too old for this shit. I'm too old for this shit. If you're watching, come into chat.
We got transferred.
So, and Mr. Payton was also sentenced. Sentence was imposed upon Mr. Payton in June of 2017.
I don't know. I know he got out of jail. I didn't really know all the details. He got out of jail after that.
So you don't know all the details after the case was sent back?
What country is that big lake over the ocean? You got the ocean, but then you have this great big gigantic lake that is over the ocean. Oh gosh, I gotta find that picture and change my background to that.
To the lower court, you don't know all the details?
That's not what I said.
Okay. So what did
He
you say?
asked me
Mr.
about after my involvement in that matter concluded.
When did your involvement conclude?
At the hearing. At the time, I wasn't a lawyer. I just came forward as a witness to help this man. And I mean, I don't know what Jarvis is. I don't know what happened after. I just know one day I got a phone call and it wasn't the prison number. It was Jarvis. And he was on the street, and that's it.
Okay. And do you know the race of Judge Campbell?
He's from Panama. He's an immigrant from Panama.
Judge Campbell is not white, correct?
No, he's not.
Okay, thank you. Now, you talked about the federal court case that you were involved in with Judge Prater.
Yes.
Okay. And is it your testimony that Judge Prater's decision-making was influenced by her ex-law clerk?
Yes, absolutely. Yes.
And the only evidence you have is a LinkedIn page for Mr. Miller, and you deduced that that's what must have influenced Judge Prater because of the past relationship with Mr. Miller.
That's not accurate. I didn't say it like that.
Then tell me what you testified to yesterday about Judge
Gotta
Prater.
repeat all of that?
Well, not repeat it, but how did you come to the conclusion that Judge Prater was influenced by Mr. Miller?
Paul Messing came forward and testified that I did not ask him to commit any crime fraud. We had the transcripts from the prior proceeding with Judge Dozell. There is no discussion of crime fraud. We just didn't agree on strategy. John Coyle submitted a who issued it?
Wait, what I'm asking you, Mr. Bell, I'm not asking you to go through everything you said yesterday.
All right.
What evidence, besides what you testified to yesterday, what other evidence did you have at the time which led you to your opinion that Judge Prater was influenced by her ex-law clerk, Mr. Miller, besides what you testified yesterday to?
I object to that question. It's assumed that he didn't give a complete answer yesterday, so it would be asked and answered.
I don't think you need to ask him to restate. This was a lengthy part of the testimony.
I think it would be a really, really bad idea for Brenda to take a vacation right now. I mean, right now it would show poor judgment.
Yesterday, if you have additional questions, or if you want to ask him, were there any other reasons besides what he said yesterday?
I think that's what my question was.
I don't think so, but you can.
My second part of my question was, besides what you testified to yesterday, what other evidence did you have to come to the conclusion that Judge Prater was influenced by Mr. Miller? So I said, don't testify. I didn't ask about yesterday. What other evidence? That's what I asked him.
Okay. Whatever you asked him,
He presented all of his evidence, so his case in chief is done. So, again, Thank you, Zach, for getting this whole hearing for us. Appreciate it. Thank you.
The question before you now, Mr. Bell, is, other than what you testified to yesterday, do you have any other basis for that statement?
No independent basis besides what I testified to yesterday.
Okay, well, thank you.
Just trying to move us along.
Oh, I understand that. I want to move along too. I understand. Now, can we go off a live stream because I want to ask some questions?
Go off the live stream, please.
She asked a ton of questions there. They were off the live stream for a significant amount of time. Zach, thank you so much for the gifted memberships. Giggsy got a membership. That's awesome. Good job.
We're live.
Hey, thank you. Mr. Bell, can you turn to ODC 52?
Just give us a minute. Oh, we switched binders again.
Okay, now she's going back to her evidence.
I'm sorry, ODC 54. I'm sorry.
Yeah, that's still her evidence.
Okay, for you, that's in the same binder.
Yes.
ODC 54.
ODC 54 of 1873?
Yes.
Now, yesterday, you recall Judge Schulman's testimony, not Judge Schulman, Judge Wallace's testimony, correct?
Yes.
Okay.
It's going to be beautiful.
And you testified that you were a little bit taken aback because you believed that she said something about black juries
Yes, I thought she made that complaint.
in the DB7.
Yes.
Okay. Now, do you see the second paragraph on this DB7 letter?
Where it says.
It is also important?
Yes,
Okay.
I see it, I see it.
So it's in this paragraph, we say that it's important for you to understand that it is the obligation of our office to develop all information relevant to a complaint, including information which may justify or exonerate the alleged actions of the respondent attorney or mitigate the seriousness of any violations that may have occurred. Do you see that?
Yes.
Okay. So in this DB7 letter, we're explaining to you that you developed the evidence, correct?
The weather is gorgeous right now.
We developed all information relevant, correct?
If that's what it says,
Okay.
yeah.
Now,
Everything is so
I'm not going to say
green.
anything confidential, but going back to the DB7 in the Schulman Commons matter, when you got our explanation about why we included an allegation, did we tell you that it was from our own investigation that we got that paragraph, the allegation? Do you recall us telling you that we developed it through our own investigation?
I recall something like that. Yeah, but you just went over it.
Right.
Yeah.
And you received that letter, I believe, in March 30th, 2023, correct?
I received the letter.
Okay. And this DB7 letter is dated April 3rd, 2024, so it's a whole year after you received our explanation in the Schulman matter.
No,
That's
they're both different. The magic show and the music show are both different. I mean, some of the same things are in it, but they're both different. And if you call and just use my name, you can get whatever tickets you want.
yeah, I
Hi,
guess.
Billy.
So in this letter, you were talking about, you testified that some of these emails were private emails between you and Mr. Hubbard, correct?
Yeah,
I was
there-
wrong. I can't remember. I was wrong. You did see, and yeah, it is the same one. I thought you came last season, but you didn't. Same one.
Emails between
Okay.
me and Mr. Hubbard. We'll say private. If I said that, it's not private. It's
Okay.
communicated to someone else, but yes.
So would it be safe to state that the allegations that were put forth in this DB7 that was initiated by Judge Wallace, that you made assumptions, that she made the allegations, she made all the allegations contained in this DB7.
Because you said this is the complaint of Judge Wallace, that's why. I wouldn't have did that if you look at the DB7 from the Robrino case, you don't say this is from Judge Robrino. You say it's from us. It's
Right.
from it's from the ODC. So I knew Judge Robrino didn't want to be bothered because he didn't complain. But you literally listed the judge's name on there, and I thought she didn't like black people.
So,
Because you said this, if you look at the front page, you said Judge Stacey Wallace, she didn't send this, or her allegations are, she not complaining that I said black people serving on jury, but I thought that because of what you wrote her name here.
okay, and when you, I don't want to say that, okay. Not mentioning names, and I'm not going into confidential stuff. Have you ever received, strike that, I'm not gonna even go in there, okay. But you agree that on this paragraph, the second paragraph in the first page, that we have obligation to develop all information. You didn't see that when you read this?
I mean, it says that, it could say anything on there. I'm just judging the situation based on the conduct.
So did you believe that Judge Wallace had private emails between you and Mr. Hubbard?
I really, 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 really was on his side at the beginning. I wanted him to prove it so bad, but his evidence are things like, well, that guy looked too comfortable in the courtroom, so there was discrimination. That guy looked too comfortable, and he kept saying it over and over again. Well, in this other case, his brother, come on, dude, come on. He didn't show what I hoped he would show.
Mrs. Ammons, based on how this is written, respectfully, it's very deceiving. I thought Judge Wallace had some serious problems, and now when I actually seen her complain, as I said yesterday, I feel totally relieved.
So
It says she wrote this. That can answer your question.
it says she wrote it, okay. So automatically, you went to the conclusion that she doesn't like black people.
Why would an appellate judge ask a lawyer to be disciplined because he said black people on juries? That was mentally, that destroyed me. I lost so much faith in the system when I read that.
Now, but this DB7 also has other allegations, not just black juries, correct?
Yes, and it all says it's coming from Judge Stacey Wallace.
And doesn't it say, I'm not even going here because that's argumentative. Okay.
No, it doesn't.
Thank you.
That was wrong.
I think we understand your point.
I don't think so, Jasmine. But I don't know. So, besides calling Judge Wallace a racist, he also accused a bunch of lawyers of being racist. That is private information, so we're not allowed to hear that. But it's the same thing, it's the same cases, everything is the same. So I don't think they gave a lot of information when it was off live stream. I think it was the same information we got with Judge Wallace, only insert the lawyers' names in there instead. I could be wrong though, I don't know.
And that's why I'm moving on. And I just lost my train of thought.
Good.
Indulgence, I just lost my train of thought, I'm sorry. I think you already answered that question. I have no further questions. Thank you.
Doctor, you have any redirect?
Yes, two questions. With regard to that Carol V. Anders case, when you prepared your motion for recusal, the case, was that case still pending?
I'm not sure. At that, like in my mind, when I was preparing it, I'm not sure whether I can't recall whether I knew the if the case was pending at the time. But I do know that the case was put into arbitration while that matter was pending. I did confirm that.
Do you recall how the Carol B. Andrews case actually ended?
I don't have personal knowledge. I know what the opinion says, and from my understanding of the opinion, Judge Anders' brother, Peter J. Anders, he was facing an opponent who was a pro se litigant. Mr. Artist was a pro se litigant. I think he's just got out of jail or something like that, and he didn't understand the process of the courts. And if you read the entire opinion, I'm going from recollection, if you read the entire opinion, the judge was very good and gave him a lot of chances before dismissing his case. And if you read the last page that Mrs. Anders showed, the litigant didn't even attend the proceedings, and it was no conclude. That case didn't conclude because Judge Anders' brother was exonerated. I just think he was up against an opponent who wasn't prepared and didn't have the resources. He didn't show up to any of the proceedings. He didn't even, if you read the complaint, the memo, I just think the client just was unprepared. Not the client. The plaintiff was unprepared for the battle that was ahead of him. But in nowhere did it say Judge Anders' brother is 100% innocent. And when I filed my motion to recuse, I wasn't really trying to attack his brother. And I don't know. So look, I'm not trying to attack his brother. It's just at the time that the cases were put in arbitration, that matter was pending. And we thought it would be relevant. And that's as far as I was trying to go with that issue. Didn't even argue that on appeal.
Now there were a couple of questions about the case law that was used in Judge Wallace's opinion. I want you to go back to what is marked as Exhibit 42, and I'm going to go to base number 705.
Which
Our
exhibit?
It's found in Exhibit 42.
What's the page number?
705.
I'm here.
Okay. All right, I'm going to take you to the last paragraph on the left column of page 705. And you were asked were the halls in a similar situation was it similar facts as your case? I want to refer to the line that says, at a pretrial conciliation, Judge McGowan, over objection by counsel for the halls, ordered case transferred to arbitration. The hall's motion requesting that Judge McGowan reconsider his order was denied. Subsequently, the halls failed to appear at the scheduled arbitration hearing. Is that, are those facts similar to what happened in your case?
Yeah, those facts that is the fact pattern that we were faced with. And I was aware of this in my client's case.
Now, you said that Judge Wallace cited this in her opinion, but cited it incorrectly. Would you consider that, how would you consider that? Would that be case fixing? Would that be a misapplication of the law? How would you consider that?
I'll object to that. Case
Well, let me ask it a different way. How would you, if you go to page 712 of the same case, same exhibit, I'm sorry, not 712. This is not 712. It's 706. Now, this case came before the court because Judge McGowan denied the halls a trial de novo after they appeared. Is that correct?
That's accurate.
What did the court say about Judge McGowan's order?
Look, the court said a lot. All right,
Well-
I'm not trying to be.
Well, I'll take you to a direct point. I don't want to be too long. Page 706, the first paragraph on the right, the very last sentence, starting with nevertheless.
I'm sorry, where are we? Nevertheless, we conclude? Is that what you're talking about? Okay.
Yes, could you read that sentence?
Nevertheless, we conclude that the halls comply with all the necessary steps in perfecting their appeal and that Judge McGowan erred in quashing their appeal for trial. The order is reversed and the case is remanded for proceedings consistent with this opinion.
So essentially, Judge McGowan did what Judge Anders did, was denied them a trial de novo after they failed to appear at an arbitration hearing.
Essentially, this is identical.
And they're saying that the judge erred and denying them that motion.
But that's not what the Commonwealth Court ruled in their opinion.
So when they cited this, they didn't cite the holding.
No, not at all. They, no, Judge Wallace said, that panel, they didn't cite that at all. And we actually briefed the issue in the Commonwealth Court. If you look at the briefs, we actually discussed this case. And they, the Commonwealth Court just relied on 706, that last paragraph, which say we do not under any circumstances countenance the temerity of the member of the bar who instructs the people not to go to arbitration. That's that, and yeah, they emphasize that. And when you read the opinion, it appears as though like me and my clients just try to make up fake rules. It doesn't look good on the opinion because it doesn't tell the whole story about what happened. It doesn't say anything about the holding in the Hall case. The court relied only on this quote, to chastise me.
Now, Ms. Ammons brought up in that same exhibit, the Pellegrino versus Hetalka and Genevieve Fox. I want to go specifically to page 712. And you had a question was whether these litigants were in a similar situation in yours. Could you read the first sentence in the first full paragraph, starting with in connection?
In connection with the first two issues, these names. Catolka and Fox raised for the first time the question of whether entry of judgment on July 11, 2012, based upon their failure to appear at the arbitration hearing, is void for lack of subject matter jurisdiction. In short, Catolka and Fox cite to, among other things, this court's en-banc decision in Robert Half International versus Molten Technologies. Based upon our...
I only wanted you to read the first sentence.
Oh, I'm sorry.
These litigants are appealing because they had entry of judgment for them failing to appear at arbitration hearing, correct?
That's accurate.
And essentially, can you go to page 716 of that same piece? And can you read the very last sentence? Well, actually, can you read the last paragraph?
All right. The trial court's order entered on February 26, 2013 is reversed. The judgment entered in favor of Pellegrino and against Catolka and Fox in the amount of $12,211.20, and the judgment of non-suit entered on the counterclaims of Catolka and Fox are both hereby vacated. The case is remanded to the trial court for further proceedings consistent with this decision, jurisdiction relinquished.
So essentially, this is another, this is a similar situated litigants who had failed to go to arbitration, had an entry of non-pros entered against them, and they had it vacated, and they were given a trial.
That's accurate to the arbitration statute.
Now, next, Ms. Ammons mentioned that when you had the case with, when you sued the city And can we go on live stream just briefly?
Yes, let's go off the live stream, please.
We are live.
Just in brief indulgence. When you that I want to ask this because you were asked about why you believed you were being, how to say it, targeted by judges, how you were being targeted by judges. What did you believe was the reason, or what is their basis for believing that these acts were targeting you or were done to affect your cases, the outcome of your cases?
Well, and just to be clear, I'm not talking about all judges. Not like it's not one of those. I'm not saying that. On certain cases, like certain civil rights, anytime you challenge the city, not every case and not every judge again. So I'm very clear. It's just I noticed that there is some disparate treatment, and it seems like when you bring a case against the government, they give him a lot of leeway, like in the Rubino matter. Like the only one who must follow the rules is me, and every time opposing counsel who's representing the city, they get substantial leeway. It's like they could do no wrong just in front of certain judges. I'm not saying all judges. It's just that I've noticed that I'm being treated differently than other people on these cases. Not every judge.
Do you have any knowledge of
Thanks, Pete.
any other cases where judges may have exhibited disparate treatment?
Objection. This has nothing to do with Mr. Bell. Are you talking about?
Overruled.
What,
And you're talking about in Philadelphia County, or you ain't talking about everywhere in the world, right? I know that. I'm trying to be.
locally?
Oh,
Philadelphia, our state.
yeah. I mean, so again, you know, gotta be careful when you talk about judges, but yes, I am aware. I mean, there's some public incidents that really informed my interpretation of certain actions, and just Philadelphia, we had certain.
That's how I sit in most chairs because my feet don't reach the floor. I just swing my legs.
Judges indicted for case fixing, writing false orders for their friends. Look at the situation with the traffic court. I think we had to close it down. And judges got arrested because of fixing cases and doing favors for friends.
Can I have you look at what has been marked as Respondent Exhibit 62, page number 1121?
There.
All right. What is Exhibit 62?
This is an Inquirer article talking about Justice how he wrote a false order for his friend that he met at a bar.
I'm going to object to this as irrelevant hearsay, unless he's testified as to his state of mind. And
Not good?
That is what we're offering for, his state of mind.
Well, then you gotta ask him first if he saw this article before and why. And then we'll rule the objection.
Have you seen this article before?
Yeah, I was well aware of this. This was way before was I even thinking about being a lawyer at this time? Yeah, this was the talk of the town. This and other matters.
What other matters were you aware of?
Go ahead, Mr.
what other matters that you were aware of at the time these allegations were made that influenced your state of mind as a court's position?
And I'm talking about public matters, like matters that was reported and there's actually discipline on judges. When I say that, that's what I mean. I knew about this matter. This was a talk of the town. I knew about there's other matters. Some judges got they were put on the wiretap fixing people's cases in the Philadelphia Court of Common Pleas. That was done in 2004, around 2014. I think it was Judges Roca, Siegel, and Waters. They was on the phone. They got put on the phone talking about sabotaging somebody's case because he had a disagreement with somebody's friend. And the FBI had a wiretap on him looking for something else, but they heard that and brought charges. Had the situation with the traffic court, that was way before, that was like 2010 or something around there. I think they didn't close the traffic court, but the Pennsylvania Supreme Court had to intervene because everybody was taking bribes to fix tickets and stuff like that. And I think like 7 judges got actually indicted and went to jail, got probation or something. So this is way before I was a lawyer, but around 2010, around that area, 14 was the Rocco Siegel matter. I'm aware of this history and this other matters too, but this is public knowledge. And you can even go to the Judicial Conduct Board and see some of the judges' records of what they did. And I'm not saying every judge, and most judges wouldn't even engage in this type of nonsense, just so we all clear. But I am aware of this stuff. I know it happened. It happens sometimes. Yes, I know that.
And does that influence in any way your state of mind as to what happened to you?
Well, with the Anders motion and his brother being a cop and how he made the ruling without any hearing or that played a lot. That played the information that I knew at the time. And then we had this situation where they wrote the ain't no black beat. It's going to be a judge or president judge of municipal court with Judge Simmons, and that was in that cure report. But that cure report was issued like a year after that happened. I remember I just got my law license. It was like fresh off the paper, and I remember that.
Can I pause you for clarity? I didn't understand. You said somebody wrote ain't no black, like what was written, where was it written? I'm not understanding where you said. Was that in the paper?
I'm sorry, because I assume everybody in Philadelphia knows, because everybody I know about this. So the judges, they have a secured section of the courthouse where only they can go. They have an elevator that only the judges use, and then they have like an area. It's not, I don't think it's their official chambers, but it's where, or maybe it is. Yeah, of course it is. But in the chamber section, where only the judge and their staff have access to, and this was widely published in the newspaper. Somebody wrote when Judge Simmons was running to be president of the municipal court, they wrote, ain't no black, you know what, well, you don't know what, but I'm not gonna say it. It's going to be the president of the municipal court, and that caused a lot of stir in the FBI investigation. But it was only in the area where other judges could have access.
Where did you said somebody wrote it, but you didn't
On her door.
Oh.
On her chamber's door. And that was widely reported. That was actually in the Keel report that we talked about yesterday. But so, and when Mr. Landau asked me, did the Keel report happen before or after these matters? It was like around the same time, and I was thinking, because I was thinking that the Judge Simmons matter, that was reported like a year before the publication of the Keel report. So I was trying to get my timeline together. And yeah, I was aware of that incident, other incident, widely published incident. I'm not talking about subjective, no, I'm talking about stuff that I just assume everybody knows.
I don't have any other questions.
Recross.
Yes, definitely. Mr. Bell, your counsel asked you about the Reed opinion that we discussed earlier.
Yes.
As you said it before, this case involved an appeal from the arbitration award, correct?
The Reed matter.
The Reed, correct?
The arbitration award.
Was
Whatever it says.
this did not involve an appeal from a non-pros, correct?
I've had to look at it.
You asked this on
Okay.
cross and he answered it.
Your counsel asked you a question that this is the same thing that Judge Anders, the judge in this case, Judge McGowan, I think his name is, it's the same thing that that Judge Anders did, correct?
Essentially.
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 Isn't it true that Judge Anders did not deny your relief for a non-pros, correct?
Judge Flateman.
Right. Judge Anders did not enter non-pros, correct?
Judge Flateman did that on both cases.
So it wasn't Judge Anders,
I guess, yes, it wasn't, yeah.
okay? Now, according to the articles that your counsel told you to look at in 62 and the Clear report, which I think was 60, nowhere in those documents whatsoever is Judge Anders' name, that his name appears, correct? In regards to racial bias or case fixing or ticket fixing, Judge Anders' name does not appear in any of those articles or in that report.
All right, so I can say, because right now I don't have a recollection, so you asked me to read them. From what I recall,
It's your exhibit. It's your exhibit. Nowhere in your exhibits is Judge Anders' name.
that appears to be, from what I know now, or excuse me, what's in my brain at the moment, I think that's accurate.
And to your knowledge, Judge Anders there has never been a judicial determination that Judge Anders engaged in misconduct where he was racially biased against any participant in civil court or criminal court. To your knowledge.
I can't answer that because judicial matters, that's private, even if they're reprimanded.
I'm not talking to Mr. Bell. I'm talking about court cases. That's what I'm talking about. I'm not talking about judicial conduct board, which is confidential if there's no finding. I'm talking about cases where Judge Anders presided over in criminal or civil court. There has been no judicial there has been no appellate opinion from either the Superior Court, the Commonwealth Court, or the Supreme Court of Pennsylvania that Judge Anders engaged in misconduct at all, correct? In regards to racial bias.
How would I know that?
You're right. How would you know that?
I mean, nobody asked me to review it. I mean, I don't know what I would find. I didn't review. Now, if you send me on the task and ask me to find something, then I'll look. But I never had the occasion. The question you present was never addressed to me.
When you did your motion to recuse, did you do any investigation in regards to Judge Anders besides his brother?
I investigated the law that was in front of me that we were dealing with. I didn't go on a seek and destroy mission to find everything out about Judge Anders. I don't even know the man, and I only mentioned that article that I saw because it's blasted in that newspaper that I mentioned, and my clients they told me about it before I even bothered to look. So, yeah, I was just operating off what was in front of me. He's a judge, and he deserves his privacy, so I wasn't trying to.
We're not talking.
All right, yes.
We're not talking about private matters,
Okay,
which you mentioned earlier in your testimony. We're not mentioning private matters. I'm talking about judicial matters. I'm talking about his role as a common pleas court judge.
I didn't investigate if there was any other cases.
Okay, thank you. I have no further questions.
Gonna move my exhibit.
Well, the panel may have some questions for Mr. Bell first, and then we'll get to that. So I know I have a couple questions, and the other committee members might as well. Mr. Bell, regarding Mr. Miller, you explain, was Mr. Miller a party in the case before Judge Prater?
Oh, okay, that's confusing. I'm so sorry. All right, no, so, wait, there's so many Millers. Hold on. You talking about the end? Oh, all right, me now.
Oh, maybe there is. I mean, your discussion of the former law clerk.
Oh, okay, all
Was
right.
he a party, a named party in that case before Judge Prater? I thought you mentioned something about some related case, and I'm just trying to understand what was his role in the case before Judge Prater?
All right, so, I did file a case against Miller, in that matter. But it was assigned to a different judge. Judge Prater became aware that that action was pending when we had the hearing. We had that subsequent hearing on the Rule 68 motion. But she did not preside over a case where her law clerk was the defendant. And I'm sorry if I wasn't clear.
No, I think it was just a little bit unclear, so I'm glad you clarified that. At what point in the proceeding, to your understanding, did Judge Prater become aware of this other case in which Mr. Miller was involved? If she did.
She became aware prior to the actual hearing.
How do you know that?
Because I think either I emailed her or she knew the case was pending because we let her know. I think I let her know. I forgot how it came about. But it was like, it wasn't a secret because the matter was filed, and I'm not sure whether I told her directly or the city mentioned it at some point.
Told her that there was another case, or told her that Mr. Miller was involved in it?
So that Mr. Miller was a defendant, because I forgot exactly how. I forgot exactly how.
And what did that second case have to do with the relief you were seeking to change the Judge Dalzell's order? How are those two matters?
All right, because Mr. Miller, all right, so John Coyle, did I say it?
That's fine.
Okay. Mr. Coyle had authored the declaration / affidavit, and at that time, Mr. Coyle, he had left the law department. He was with the school district at that time. Mr. Miller was with the city's law department, and he filed that declaration for the city. And it's my position that everyone in the city, they knew Paul Messon and Radowski did not withdraw because of a crime fraud issue. And my position, representation to the court, was that he known that, or he should have known that before he submitted John Coyle's affidavit.
But you filed a lawsuit against Mr. Coyle.
And Miller for submitting that. Yes, in the law department.
So Mr. Miller was a defendant in the other lawsuit where this prior order of Judge Dalzell was being used.
All right, see, I was very confusing.
Sorry.
And I'm so sorry. All right, all right. So, he was not a defendant at that time. In fact, I think looking at his LinkedIn, I think he was actually working with Judge Prater at that time.
Right. Well,
Yes.
so what I'm just trying to understand, all right, is the lawsuit that you brought against Mr. Coyle.
Yes, and with Coyle, Miller, and the city, yes.
So Mr. Miller was a defendant in that lawsuit.
To the best of my knowledge, yes, he
He
was.
wasn't counsel in it. He was.
No, you're right, you're right.
Okay, thank you for clarifying that. You testified yesterday about seeing Mr. Orvik and Mr. Hubbard together at some point.
Yes.
Was that while the Miller and Murphy cases were pending or after?
sort of
It
both.
was, it would
Give me
be
10
why
seconds.
if they were pending, but it wasn't like right after the case management conference. It wasn't like, oh, right after the case management conference, they was out drinking coffee. No, it was some time after.
Okay.
Okay. So we have a tiny little idea of what they're thinking based on his questions. So it's both, Jasmine. So we don't have a final resolution, as in we don't know if he gets disbarred or censored or this case is dismissed, or it's sort of like a pretrial conference. Sort of like, so they go in front of this panel, and then this panel will give a recommendation to the Supreme Court to figure out, or to the Office of Disciplinary Counsel, whatever the next step is before it keeps going up the chain until he's either dismissed or censored or sanctioned or disbarred. So we don't know those yet, but we will know whether it's dismissed or not. We will know whether this panel has found enough information in these hearings to push it forward to the next process, which is their recommendation of what to do with this lawyer. So we're going to find out tomorrow if the state or if the Office of Disciplinary Counsel has put forth enough evidence to prove that this lawyer did something wrong. We're going to find that out tomorrow. Thanks for coming out, guys. Appreciate it. I'll see you again really soon, okay? Have a great day. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, Come and see for yourself.